Greetings, I'm Bob Owen. This is Meghna Shah. We're litigation lawyers in Sutherland's New York office. We're here today to talk to you about the attorney-client privilege and to give you some do's and don'ts as in-house counsel. The attorney-client privilege is at the very core of our legal system. It allows clients and their lawyers to discuss their legal problems without fear that their consultations will be disclosed to the other side or to the government. Historically, the privilege has been applied fairly uniformly to outside counsel as well as inside counsel. The courts, however, are starting to make some distinctions that we think it's important for you to know.
The primary reason that courts are making these distinctions is that in-house counsel have increasingly taken on a number of different roles. They wear many different hats in corporations today. In addition to serving the companies as a lawyer, they often also assist with internal investigations and regulatory compliance. They assist with fact gathering. They often provide business or financial advice, and they serve some administrative functions as well. Because they wear so many hats and because in-house counsel are taking on the broad range of roles in increasing numbers, courts are heavily scrutinizing communications that are withheld that involve in-house counsel.
This means that it's important, more so than ever, for in-house counsel to be careful about their communications and not to make any assumptions. We've prepared a short list of do's and don'ts that we hope will be helpful to you.
Here's a couple of proactive tips that you can take to ensure that your privileged communications are protected. One, be sure you separate legal and business advice whenever possible, even if that means just separating those two discussions in a single email. Make sure you train employees to indicate that material was explicitly gathered at the request of counsel when they are gathering materials for you, and make sure you're equally explicit in responding to requests for advice or asking for particular materials as well. Make sure that you use your legal title in a signature block if at all possible. If you're able to separate your legal title from a business title, that would be ideal. But if that's too cumbersome, be sure to use your legal title on its own whenever you are rendering legal advice.
On the don't side, the most important thing for you is not to make any assumptions that just because you're an attorney, anything that you do is privileged. Don't overuse the attorney-client privilege stamp. Don't assume a communication is privileged just because you labeled it as such or because you're copied on it. Don't ever use the reply all function when providing legal advice because you may inadvertently breach the privilege in that moment by sending it to people outside of the privilege. Don't attach privileged documents to non-privileged communications. And don't address legal memos only to file. Send them to the department or person requesting the advice.
If you'd like any information on our full in-house seminars on this or any other topic, please feel free to contact us at the numbers or email addresses listed on the slide. Thanks for watching, and please check back here at Sutherland.com for more videocasts.
Thank you.